exercise its honest judgment in this case. The jury's verdict was on account of the improper and unfairly prejudicial evidence that Mr. Iliopoulos introduced. The case law that we cite in the brief says that wherever incompetent evidence may have influenced the jury, there must be a new trial. That's the Middlesex supply case at page 375. This verdict is unlawful. The verdict is the product of passion and prejudice of the jury. And moreover, as we point out in page 14, the verdict is also, in page 14 of the brief, the verdict is also internally inconsistent. For those reasons, Your Honor, we would respectfully request that the court allow Mr. Van Lieu's and Hoch's motion for a new trial, or, in the alternative, remit the damages in this case to a nominal amount as has been requested in the brief.
Limiting instructions to the jury. Many of these instructions were agreed upon by the parties. I'm not suggesting that they agreed the evidence would come in, but once the court made clear it intended to admit the evidence, language that was acceptable to them, telling the jury, you may consider the evidence for this purpose, but not for this purpose, again and again and again and again throughout the trial. That was the appropriate way to deal with this evidence that in each instance was relevant and admissible for the purposes for which we sought to admit the evidence. And purpose of Mr. Van Lieu sued Mr. Iliopoulos for making a statement to the Lowell Sun in that email to the reporter, Rita Savard, I think her name was, where Mr. Iliopoulos was being sued for saying that Mr. Van Lieu has brought, forget the words he used, but a lot of bad litigation against a lot of residents of the town of Chelmsford. One of those pieces of litigation was a lawsuit Mr. Van Lieu filed against Colleen Stansfield. That lawsuit included, and the reason why that was admissible really was for two reasons. One, and by the way, we didn't offer it to evidence, the complaint, just the subject matter of the lawsuit. Number one, Mr. Van Lieu sued for intentional infliction of emotional distress, the same claims he was bringing here, but more importantly, that went to Mr. Iliopoulos' state of mind. This was the basis of my statement. This was my belief. This is why I said he had been involved in this litigation, and he explained what happened. I don't know what this stuff about Mr. Iliopoulos committing perjury, but this transcript that apparently was out there, Mr. Hoch had 20 hours on cross-examination of Mr. Iliopoulos. He could have elicited all of that. I don't know what he's talking about, but he certainly wasn't foreclosed by anybody, especially this court, of conducting a fulsome, complete, and comprehensive cross-examination. The Choose Chelmsford Quinacrin evidence, we talked about that at length in trial. Again, it wasn't Mr. Iliopoulos who opened the door to that. Mr. Hoch asked Mr. Iliopoulos on cross-examination about this Choose Chelmsford timeline in trying to imply and suggest to the jury that the Iliopoulos oligarchy, so to speak, had been involved in trying to harm Mr. Van Lieu in all these other ways. He opened the door to it. I asked him questions about it. Not only did I ask questions about it, but again, Mr. Van Lieu admitted on cross-examination, yes, this timeline hurt my reputation. And if you remember, before I asked Mr. Van Lieu a single question about it, I telegraphed the issue to the court, and the court gave me very specific instructions about the type of questions that would be appropriate to ask Mr. Van Lieu. And the question was something to the effect of, isn't it true that you've taken controversial positions with regard to a certain type of medical treatment, or something innocuous and vague enough? And Mr. Van Lieu said, no. And so we went over to sidebar again, and I sort of shrugged my shoulders, and we all said, and you said, well, you now can go a little bit further into it. We went over to sidebar again, and you said, why don't you ask him this one question? Isn't it true that other people may perceive that what your position is on this particular issue is controversial? And then he gave me the yes, and I moved on. You did, again, instruct the jury in a limiting way that they could only consider this evidence for purpose of reputation. The McClure ethics opinion, very briefly, discerning, very careful, very deliberate. You kept telling us throughout the trial, you're not giving the jury enough credit. They're listening, they're careful. They observed his demeanor, they observed his character, they observed his emotions, his helplessness, his anxiousness, his embarrassment. Mr. Hoch referred to those as crocodile tears in his closing argument. Ultimately, the jury decided. The jury made an assessment of Mr. Iliopoulos' testimony and credited it. And a $250,000 emotional distress damages award does not shock the conscience. The last piece, I think, is on the reputational damages. Yeah. And part of the mosaic of evidence that was presented to this jury, which plainly support the award. You know, they made some reference in their papers to, you know, well, it's the highest verdict of this, that, and the other thing. It's not. But as Judge Gant said in the Clifton case we cite and we attach, evaluating a damages award in terms of what other juries have done is of limited value. Because every jury is different, every case is different, every set of facts is different. And they can say, well, in the Judge Murphy case, it was only $2.3 million, and that was in a national publication. Well, we can say in this case, this went on for 5 years. So it's apples and oranges. It's plainly supported by the evidence, and that's what it doesn't shock the conscience. It was a well-reasoned, thoughtful decision by this jury. Your Honor, all this stuff's in our brief, all of the evidence that supported the verdict in the brief, much of it. I've already taken up more time than I expected to.
But it's not just the First Amendment to the federal Constitution, it's also an Article 16 case under the Massachusetts Constitution. This verdict must and should be set aside. It is contrary to First Amendment law. It's contrary to Article 16, which some authorities say is written even more broadly than the First Amendment. This is the first time that you have had a chance to look at these alleged defamatory statements after the verdict. Mr. Iliopoulos' case should have been thrown out at the summary judgment stage. It should have been thrown out at the directed verdict stage. But at this point, it is now time for this court to do a searching reassessment for each statement that is required under the Murphy versus Boston Herald case that Mr. Rich just cited. This verdict tramples the First Amendment regarding political speech. New York Times versus Sullivan explicitly allows for sharp, caustic, unpleasant, strong debate, statements concerning the actions and conduct of elected officials. In his July 26, 2010 statement, and admitted at the Chelmsford Forum on June 23, 2010, that he intentionally failed to brief the chairman of the Board of Selectmen on March 16, 2009, in an attempt to shield him from an ethics charge. You can't get much more of a backroom deal than that. Later on, after Mr. Iliopoulos left the Board of Selectmen in September of 2009 decided they weren't going to do anything. That's another deal. Claire Janot was feeding Mr. Iliopoulos private information in her capacity as a selectman after Mr. Iliopoulos left the Board from anybody who was criticizing the deal, asking if the deal was legal. Those emails were introduced as evidence in the case. Again, you can't get much more of a backroom deal than that. There was no recusals. There was no disclosure, ever. The ethics letters were also misconstrued by Mr. Cohen and other town officials. Nowhere do either of the ethics letters say that the Ethics Commission looked at Mr. Iliopoulos' conduct in representing his father or town interest in 9 North Road, and therefore determined that there wasn't a conflict of interest. Despite the fact those letters shouldn't have come into evidence, once they did come, the statements made about them by Mr. Cohen and other town officials show that that was a backroom deal. We've already talked about the ethical violations that Mr. Iliopoulos committed, which are illegal and which are criminal acts, and that those violations existed regardless of whether the town used the land to expand the center fire station. Brief, Your Honor, virtually everything a town talks about is automatically deemed a substantial interest within the meaning of the ethics statutes. The fact that Mr. Cohen said it wasn't substantial, the fact that Mr. Maloney said it wasn't substantial, that testimony at trial has nothing to do with whether Mr. Van Loo was correct in 2009, 10, and 11 to take a different position, because he was aware of this. Mr. Iliopoulos' claims were published by Hoch, which of course we disagree with, were permitted political rhetoric, even if the statements were correctly attributed to him. This is political speech And this verdict is inconsistent with Hutchinson versus Proxmire. That case stands for the proposition that it is important in this country to ensure vigorous public debate about public issues and the conduct of elected officials. Even if there was no First Amendment, and even if there was no Article 16, this court should still vacate this verdict because Mr. Van Liew should prevail. Mr. Iliopoulos broke the law, knew of town interest, and as an example, Mr. Van Liew, Mr. Iliopoulos says, oh, the only thing that the Board of Selectmen did on March 23rd was accept a report from the Permanent Building Committee saying that they were moving to Wilson Street. That's not correct. Among the trial exhibits that were given to the jury was the actual videotape of Mr. Maloney telling Mr. Iliopoulos not once, not twice, but 3 times that regardless of where the new fire station went, the town should buy the land behind the fire station to enhance the value of that town-owned asset. That made it, at the very latest, that made it an ethical violation for Mr. Iliopoulos to sit there silently, not to make a disclosure, not to recuse himself, while at the same exact time represent his father concerning substantive negotiations concerning the purchase and sale agreement. Every person in Massachusetts to voice honest discontent with the conduct of public officials. In this case, the jury wrongfully chose to ignore the evidence in the case. The jury wrongfully chose to ignore the lack of clear and convincing proof regarding malice. The jury wrongfully chose to ignore the lack of subjective evidence. And concerning the lack of malice, everything Mr. Van Liew did was based on the best evidence he had, gathered at great expense, and vetted by multiple people and multiple lawyers, not just Mr. McClure, Mr. Kimball. And if you want to go that far, we can look at Mr. Curlin. Mr. Curlin's emails to Mr. Van Liew where he says that the preservation restriction was violated and that Mr. Iliopoulos should never have represented his father. That is also in evidence. There's no evidence that Mr. Van Liew harbored a subjective disbelief of any of the things that he printed, or talked about, or allegedly published. Mr. McClure said the PR was violated. Kimball said the PR was violated. Curlin said the PR was violated. Even the surviving Board of Selectmen member from 1978, John Carson, the jury ignored the evidence regarding an absence of malice and rendered a verdict that must be vacated. What Mr. Van Liew did and continues to do is a public service to people. Mr. Van Liew stuck his neck out, and what did he get for it? He got sued. He spent a lot of time and a lot of money educating the public about important public issues. He didn't go after Mr. Iliopoulos' personality or his personal life. None of that. He focused on political issues, economic issues, issues that were important to the town of Chelmsford. And that is precisely the kind of political speech that is allowed under the state and federal constitutions. It eliminates the right of people to speak up, and even if they sincerely believe the officials acted wrongfully, this court has the power and the duty to ensure that concerned citizens like Mr. Van Liew, who take it upon themselves to educate the public at their own expense, are not subjected to multi-million-dollar defamation verdicts for speaking truthfully, speaking without malice, speaking out against public issues, and in particular misconduct by public officials who abandon their duties in order to personally profit and enrich themselves and their family at the expense of the people they are supposed to serve. Mr. Iliopoulos claims that he waived objections to the jury instructions. That's not true. You ruled from the bench that our objections were preserved, and we relied upon the court's statement in that regard. Mr. Iliopoulos claims that we're not seeking that the verdict be vacated with respect to the findings against him. That is not true.
Anywhere in the evidence, from whatever source derived, any combination of circumstances could be found from which a reasonable inference could be drawn in favor of Mr. Iliopoulos. So Mr. Hoch doesn't get to stand up and say, well, Mr. Maloney testified to this from the trial, but that's not consistent with what he said on the videotape. Well, that was a classic factual conclusion from which a jury of 14 individuals can and did decide. And he might not like it, I understand, but that's not the stuff of JNOV. The jury heard the evidence, they considered it. On some of the statements they found that they were defamatory, on others they weren't. Mr. Hoch says that this will chill the First Amendment, this will chill people from speaking out, because people will be sued for claiming truthfully, and he went on from that. Well, of course, the jury concluded that he didn't claim things truthfully. The jury found that the statements that he made were false. So there's no issue about chilling speech, because of course, defamation only punishes false speech. And that's what the jury found. He focuses on a couple of emails and says, aha, there we proved there were backroom deals. But he ignores every single witness who was called to testify. We asked, Ms. Cook and I said, Mr. Hoch again talks about there was ethical violations, it was criminal, he broke the law. Well, you may remember, Your Honor, at the outset of the trial, you asked Mr. Hoch, you said, do you intend to call an expert?
Meaning of the JNOV rule, that's not the standard. The statements must be both deliberate and reckless, willful, not just false. Mr. Van Liew's statements were based upon a reasonable, factual basis. So for Mr. Rich to get up and say, oh, the jury found they weren't true, that's not enough. That's not the standard. The standard is what I just mentioned. For that reason, along with the other reasons we have mentioned, this is a perfect situation where JNOV ought to be entered, that there's millions of dollars in insurance. Travelers has interposed a different opinion, but there has been no analysis by Mr. Iliopoulos about insurance-related issues. He made zero effort to determine the insurance picture before he filed his discovery requests. He made zero, and the same is true with respect to his motion for attachment and his motion for post-judgment injunctive relief. It was, in fact, in this onerous discovery that he propounded, and we'll get to that in a very short amount of time, he didn't even ask for any questions of insurance, why they don't think there's insurance coverage. There's no memo, there's no analysis, there's no nothing. And for them to come up and say that Mr. Van Lieu and Hoch are judgment proof, the equivalent of judgment proof, to activate the case law that they say entitles them to an injunction is just flat out wrong. $2 million in insurance coverage by their own admission does not make Mr. Van Lieu and Hoch judgment proof. Far from it. We wanted to point out, and as we have done so in our papers, irreparable harm is obviously harm other than money damages. Only in unique circumstances is the likelihood of recovery so remote